Recognize Ms. Cohn for 5 minutes.
Thank you, Chairman. Thank you, Chairman. It's an honor and a privilege to testify on this critical issue. What does torture have in common with genocide, slavery, and wars of aggression? They are all jus cogens. That's Latin for higher law or compelling law. This means that no country can ever pass a law that allows torture. There can be no immunity from criminal liability for violation of a jus cogens prohibition. The United States has always prohibited torture in our Constitution, laws, executive statements, judicial decisions, and treaties. When the U.S. ratifies a treaty, it becomes part of American law under the Supremacy Clause of the Constitution. The Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment says, no exceptional circumstances whatsoever, whether a state of war or a threat of war, internal political instability, or any other public emergency may be invoked as a justification for torture. Whether someone is a POW or not, he must always be treated humanely. There are no gaps in the Geneva Conventions. The U.S. War Crimes Act and 18 U.S.C. Sections 818 and 3231 punish torture, willfully causing great suffering or serious injury to body and health, and inhuman, humiliating, or degrading treatment. The torture statute criminalizes the commission, attempt, or conspiracy to commit torture outside the United States. The Constitution gives Congress the power to make laws and the President the duty to enforce them. Yet President Bush, relying on memos by lawyers, including John Yoo, announced the Geneva Conventions did not apply to alleged Taliban and al-Qaeda members, but torture and inhumane treatment are never allowed under our laws. Justice Department lawyers wrote memos at the request of Bush officials to insulate them from prosecution for torture. In memos dated August 1, 2002 and March 14, 2003, John Yoo wrote the DOJ would not enforce U.S. laws against torture, assault, maiming, and stalking in the detention and interrogation of enemy combatants. What does the maiming statute prohibit? It prohibits someone with the intent to torture, maim, or disfigure, to cut, bite, or slit the nose, ear, or lip, or cut out or disable the tongue, or put out or destroy an eye, or cut off or disable a limb, or any member of another person, or throw or pour upon another person any scalding water, corrosive acid, or caustic substance. John Yoo said, just because the statute says, that doesn't mean you have to do it. That's a quote. In a debate with Notre Dame professor Doug Cassell, Yoo said there is no treaty that prohibits the president from torturing someone by crushing the testicles of the person's child. It depends on the president's motive, Yoo said, notwithstanding the absolute prohibition on torture. John Yoo twisted the law and redefined torture much more narrowly than both the Torture Convention and the U.S. torture statute. Under Yoo's definition, you have to nearly kill the person to constitute torture. Yoo wrote that self-defense or necessity could be defenses to war crimes prosecutions, notwithstanding the Torture Convention's absolute prohibition on torture in all circumstances. After the August 1, 2002 memo was made public, the DOJ knew it was indefensible. It was withdrawn as of June 1, 2004, and a new opinion, dated December 30, 2004, specifically rejected Yoo's definition of torture and admitted that its motives to protect national security won't shield him from prosecution. The rescission of the prior memo is an admission by the DOJ that the legal reasoning in it was wrong. But for the 22 months it was in effect, it sanctioned and caused the torture of myriad prisoners. Moreover, as has been stated, the March 14, 2003 memo was later withdrawn by Jack Goldsmith. Yoo and other DOJ lawyers were part of a common plan to violate U.S. and international laws outlawing torture. it was reasonably foreseeable their advice would result in great physical or mental harm or death to many detainees. Indeed, more than 100 have died, many from torture. You admitted recently that he knew interrogators would take action based on what he advised. Dick Cheney, Condoleezza Rice, Donald Rumsfeld, Colin Powell, George Tenet, and John Ashcroft met in the White House and micromanaged the torture by approving specific torture techniques such as waterboarding, which, contrary to what the Republican congressman said, I believe it was Mr. Franks, constitutes torture. And that is widely known. It has been a standard torture technique. It's been considered torture since the Spanish Inquisition. Bush admitted he knew and approved of the actions of this committee, this National Security Council Principals Committee. They are all liable under the War Crimes Act and the Torture Statute. Under the doctrine of command responsibility enshrined in our law, commanders all the way up the chain of command to the commander-in-chief are liable for war crimes if they knew or should have known they would be committed by their subordinates and they did nothing to stop or prevent it. The Bush officials ordered the torture after seeking legal cover from their lawyers. The President can no more order the commission of torture than he can order the commission of genocide or establish a system of slavery or wage a war of aggression. A select committee of Congress should launch an immediate and thorough investigation of the circumstances under which torture was authorized and rationalized. The high officials of our government and the lawyers who advised them should be investigated and prosecuted by a special prosecutor independent of the Justice Department for their roles in misusing the rule of law and legal analysis to justify torture and other crimes in flagrant violation of our laws. Thank you very much.
Thank you. And now